John, thanks for joining me today. This recording is going to be part of the Probate Empowerment Series, and the goal of that series is to provide families with a greater understanding of what is entailed in the probate process, as well as answering common questions in a manner that's not as confusing as the formal information that they may or may not have already received in their probate packets with the clerk of court. So just to help folks get to know you a little bit, I'd like to take a minute for you to introduce yourself and your firm, as well as give us a little background on why you chose probate law.
My name is John Rodgers, and I'm with the firm of Redmond, Payton, and Braswell in Old Town Alexandria. I've been involved in tax and probate law since I graduated from law school. My father was an attorney before me and did that type of practice, and so he offered me a job, so I decided to come on in and do that. And I've been doing it for close to over 40 years, I guess, since 1979. And help people. My main goal is I like to help people.
That's great, John. 40 years, man, you have seen it all, have you not?
Pretty much.
Yeah.
Seen a lot of things.
Yeah, probate is one of those things that can take so many different paths, and it can start out one way and end in a completely different manner. So let's go ahead and get into the Q&A so we can answer some of those questions.
Sure.
By the way, I guarantee that I'm going to skip around with the terms I use today. I will try to use the broad term personal representative as much as possible. But for the viewers watching, if you've been appointed as the administrator of the estate, the term executor, executrix, administrator, personal representative, those are pretty much all going to be the same qualifying terms for you. So I don't want you to get confused. So when people start out with probate, I think one of the questions that comes up first for newly appointed personal representatives is, can I handle all of this on my own, or do I need an attorney? And John, you and I both know that it's not necessary all the time, especially with small estates. However, those small estates can get very complex. And this is one of those scenarios in life where spending for professional help can actually save more money in the long run. Now, some folks are going to hire counsel no matter what. But for everyone else that may be on the fence, my question is, what are some common cues that someone definitely needs to look into hiring an attorney? And then on the other side of the coin, when is hiring counsel probably unnecessary?
I think clearly, if you have an estate where the debts exceed the assets, you clearly need to have counsel involved, because counsel may help you not to distribute the estate too fast to creditors.
Mm-hmm.
And then suddenly you're finding that you're liable to other creditors because you distributed to some creditors and not to others.
Right.
Because as personal representative, you're personally liable for shortfalls. So even though you may make a mistake in good faith, doesn't mean you're off the hook. So certainly if it's insolvent, probably you might want to talk to an attorney. If it's just a widower situation where there's a will and it leaves everything to the spouse and you don't have a lot of debt and you have assets, you may not need an attorney if you're financially savvy enough and have sufficient financial help to help you with the day in, day out kind of selling stocks, transferring stocks to your name, transferring real estate to your name, those sorts of things. Probably you may not need an attorney, but again, it's something, each person's choice as to how comfortable they are with the financial side of things.
Yeah, as a surviving spouse, there's a little less immediacy to the whole situation, correct?
Depends on the access to cash. Sometimes people have assets in their own name and not in joint name, in which case there may be some more immediacy because you have to pay funeral bills, you have to pay debt, the mortgage, things like that, and you may need access to the cash. So it just depends on the fact pattern and the situation.
Right. And, kind of as a side note, I think if someone's not a naturally organized person, if they are the personal representative, they are legally bound as a fiduciary to provide accounts and statements in a timely fashion and in a very organized fashion. So having someone like yourself on their team really makes that a lot easier for them.
Oh, absolutely. They'll having help is always good. Like I said, only if it's a situation where it just depends on the financial savvy of the surviving spouse and the comfort level they have with doing the job and keeping records and that sort of thing.
Right. And, in addition to just the organizational aspect of all this, and when to dot the I's and cross the T's, there are common landmines that can come up as well. What are some common landmines that you see in Virginia probate cases? And, are those specific to Fairfax County, or is this Virginia? Are they Virginia wide?
Well, in Virginia, each court's a little different. And some are more persnickety than others, I guess would be the way to put it. The key landmines that you need to worry about are, what does the will say, and if it's at all complicated, or if it was self-drawn by the testator, like if they went on LegalZoom.com or something like that, the deceased person, then you might want to talk to an attorney to make sure that there aren't ambiguities in the will, that there aren't problems down the road that somebody might come in and say, well, I was entitled to some, why didn't you give me my money? So those are common landmines you see sometimes. The other landmines you might see is that you distribute the estate and there's a debt hanging out there you don't know about. Do you need, are you going to make sure you got to hold on to some money a little longer than you'd want to, maybe, just to be sure there's no creditors out there that might come lurking down the road.
Right. So do you have any stories that you could share about how you've had to clean up a bad situation that was compounded due to the administrator hiring you a bit late in the process once they realized they were in over their head?
Yeah, I've had situations where administrators or executors have started, were an heir of the estate and were paying themselves money and ahead of paying the creditors, and suddenly they found themselves in hot water. That's happened several times, and then they come to me and go, "What do I do?" And certainly that's a problem. Another one that I've seen is taxes. Sometimes the deceased person was not terribly willing to file his or her taxes on time or at all, and they didn't check to see that there was tax liens or tax problems going on that they needed to take care of before they distributed the estate, and the Internal Revenue Service is not as forgiving. The other issue is, and sometimes you have you may have a death tax situation. You don't in Virginia, but you might in Maryland or DC, where you need to make sure you take care of those before you distribute the estate.
Yeah, there's so many little things that can trip people up and kind of get them into a little bit of hot water when going through probate. And that's one of the reasons when I talk to folks, I encourage them to just have a conversation with me. Now, I'm not an attorney, but at least when there are some red flags that come up that I'm familiar with, I can point them in the direction to someone like yourself that can help them navigate that. Is there a charge for just talking with you to go through a discovery process on whether they may need your assistance or not?
There may be an initial consultation fee. Sometimes I might waive it if I'm really in the dark, but usually there's a small, modest consultation fee for looking at it, and then after that we make an agreement as to what the fees are for myself and my paralegal.
Right, and with the title fiduciary that is bestowed on administrators, I talk to folks who feel that their responsibility is to spend the absolute least amount as possible, so that they will shortchange the estate administration as far as professional services go. And I just want to reiterate that that can actually cost the estate more. So that modest fee to go through the discovery process with you is money well spent, in my opinion. So speaking of, paying for professional services, how much can executors expect to pay for legal counsel, and what are the main causes of that cost increasing or billing time being added?
Every attorney, different attorneys work in different ways. Some I've heard charged by the percentage of the estate. For example, if the estate's worth so much, it might be 0.1% of the estate or 2% of the estate or some small amount like that, some percentage. And I find that for myself, that can be good and bad. You may have an estate that's rather small that requires a heck of a lot of work, and you might have an estate that's really large that requires almost no work at all. And so taking a percentage is, to me, a little bit not fair. And so I generally charge an hourly rate, an hourly fee, and I charge a much lower hourly fee for my paralegal who does most of the work. I only deal with it to double check things to make sure they're right, and to deal with the court system when things need to be dealt with in the court system.
Right. So just kind of sum that up a little bit for those that are watching. In your opinion, an hourly rate is normally going to be a better deal for the client than a percentage of the estate, correct?
Generally speaking, yes, because an attorney probably is not going to want to charge a percentage. If you have a $40,000 estate, they're probably not going to want to charge 2% of that because that's $800, and so they're probably going to charge an hourly rate anyway. But if they're asking for a percentage and you have a $2 million estate and it's 2%, well, that's $40,000, and that's a lot of hours.
And that's easy to. $2 million to a lot of folks sounds like a large estate, but around here with the housing prices, that's easy to do. So I agree with you on that, John. Currently, how long are you seeing the average probate case take to finalize, and what can families do to speed this process up, in your opinion?
Well, a lot of it depends on the time of the year when the person dies. You have an obligation to file the person's final tax return. So if, for example, the person dies in December, well, that means you can close it out a little sooner because you can get the tax return filed in February or March, and you're cleared out hopefully by summer. If the person dies in January or February, then you got to wait until January or February the following year, and then wait for the IRS to give you, process it to make sure you're okay. If there's a refund, that could take. Right now, it's taking. I have estates where I have a refund due, and the return was filed in April, and it's now December, and I haven't seen the refund yet. So, so that keeps the estates open much longer when you have that sort of situation going on. So it's really that's the main kind of slowdown. The only other thing is if obviously you get into a contentious situation with an heir, which could keep the estate open, years. Right. But other than that, I would say under 2 years is absolutely the ballpark. 18 months is probably a good average for that.
Yeah, and what I've seen, I would agree with that too, John. As far as I know, you're not an accountant. Is that correct?
I'm not an accountant. I do a lot of. I am a tax attorney as well. So I do.
Okay. Okay, great. So that's one of the things I was going to mention is folks should really consider hiring an accountant who is or tax attorney who are versed in probate law as well, because there are a lot of tax implications that can happen through the probate process, and those individuals can really help mitigate some of those taxes. If you don't have someone who knows what they're doing, you can end up paying a lot more than is necessary in taxes by not knowing the correct manner to proceed. Is that correct?
Correct. I mean, for example, a lot of people don't know that an asset has a basis increase for capital gain purposes up to the date of death value. And so it's important to get, so if somebody owns stocks or real estate, it's important to get that date of death value, because then when you sell those assets, you have a much higher basis in the property than you would if you had used what the deceased person paid for it, because many times they might have bought a stock 30, 40, 50 years ago, and it was, de minimis. So, or bought a piece of real estate, and paid $13,000 for it, and now it's worth, $800,000. So, it's important to get that information and get it right so that it helps you down the road.
Yeah, and that's a good example of when hiring a professional can pretty much pay for themselves too. So I just want to reiterate that for folks. So, you mentioned that sometimes probate can take years to finish. I'm just wondering, what are some of the things that personal representatives can do proactively? You mentioned a few things already. I'd like to talk about how they organize the process while you are doing what you're doing, what they can do in the background, and then why are some of the reasons that probate can take so long?
Well, the first thing they need to do is assemble the assets and get them under their control, and that especially in this COVID period that we're in now, that can take time, because you're dealing with entities like stock brokerage firms or insurance companies that just are slow to begin with, and then add a level of slowness to that makes it a little harder and slower. Other things, so obviously being vigilant with gathering the assets instead of sort of being passive can move things forward more quickly, because the old greasy wheel gets the squeaky wheel gets the grease is a very apt thing there. If you're calling a couple times a day or every day, if you got the time, you do it. That'll move it forward. The next thing is drilling down on what the debts are. Are there hospital bills, for example? Hospitals are they covered by insurance? Checking to make sure what's covered, what's not, so you don't have a surprise, 7, 8 months from now saying, oh, well, insurance didn't cover $100,000 of his medical bill, and suddenly now you got to deal with that. So getting ahead of the game on those issues tends to make the estate go quicker. Right.
And, when someone becomes a personal representative and they go to the property for the first time, older folks who have passed on, a lot of times they've amassed a ton of stuff. And then you've got all these pieces of unopened mail and things to go through. So, just waiting for the attorney to say, okay, now we need this, it can really add a lot of time, because there's so many things that they might have to go through to find the information that they need to find. So once again, stressing organization and being proactive in order to get this process over and done with as soon as possible is really important.
Yeah, hoarders are you see a lot of older people who are hoarders, and you can get into a situation where you have a path through a house, basically, filled to the gills with stuff, and you don't know, and did they tuck money away in books or in newspapers or in magazines, and they have stacks of them. well, somebody's got to go through and shake out all those, things to see, is there $1,000 stuffed in there somewhere, and you might find some other surprises you don't want to find, but it's certainly something you got to do. Some jurisdictions will allow you if there will park a garbage truck in front of the house on weekends, and you can use that you can fill up the garbage truck instead of renting a dumpster, or you rent a dumpster from Waste Management or something like that, and get it all stuffed away and hauled away, because a lot of it is not worth anything, you'll usually find.
Right. And you know what? That's interesting that you bring up the point of money stuffed in books, et cetera. I've heard many stories actually of older folks who did not trust the banking system and had just stashed cash throughout the house, and then they forget about it. So that's definitely something that, the administrator needs to go and check out early on in the process too. I mean, the professional fees might be paid for just in cash stashed in books and magazines throughout the house.
That's absolutely true.
So, when someone's an administrator of an estate, they are not always living in the same state that the decedent passed away in. What are some of the things that out-of-state personal representatives need to know or do differently than those who live in-state?
Well, I mean, one thing is that they're going to have to post a bond in Virginia, at least, a surety bond. So they need to be sure that they qualify, that they have good credit and all that stuff, or they won't get a bond.
Right.
So contacting a bonding company early on in the process before they qualify may avoid an embarrassing trip to the courthouse in which the bonding company says, we're not bonding this person. They've got horrible credit. They've had several bankruptcies and stuff like that. So we can't bond them. So that's sort of the first landmine. The next one is obviously travel. The court will, be reasonable in their travel costs to go back and forth to the house. Obviously, if they can hire competent people to do things and do some of the labor around the house, if there's a home involved, to clean it up and throw stuff away and so forth. But they need some strict supervision, and certainly there are very competent and honest people out there that will do that, but you need to make sure you have some agreement with them, and they come highly recommended.
Right. Yeah. And for those that are out of state, having boots on the ground here locally can really be beneficial and take a lot of the necessity for the travel out of the whole situation. Speaking of out-of-state representatives, I know that things have kind of changed a little bit during COVID as far as relaxing the rules. What have you seen change rule-wise during COVID, and do you expect that to continue in the future?
Many of the courts now are doing remote qualifications for personal representatives, whether they're local or not local, and that you can get on with WebEx or Zoom or something like that, and then they will allow you to qualify remotely, and they've set up their computers to do that. I would not be surprised if that continued after COVID, because it makes life a whole lot easier for everybody, and reduces the necessity of travel. So I would not be surprised if that continues in the future. Some are more able to do it than others. I think there's still some courts that aren't doing remote. There are very few, but there are some, especially in the more rural areas, that are not doing remote at this point in time. But a lot of them have and are now that they're geared up for it. I think they like it too, because there's not people tramping in and out of the office, and it reduces costs for everybody, because I don't have to drive out to Fairfax or Loudoun or Prince William to go qualify somebody in a probate. They get on their computer, I get on my computer, and we meet with the clerk remotely.
Right. Yeah, that's a real win-win for sure. And unfortunately for personal representatives, they can't do everything remotely. One of those situations would be an early task in estate administration, and that would be in conducting an inventory. And this is kind of a point that confuses a lot of people as far as just what's involved. I was wondering if you could simplify this process a little bit for families watching this who are unsure about how detailed they need to be when conducting an inventory.
When you're dealing with tangible personal property, that's stuff in the house, you don't need to be real precise with that. You just need to say household contents and put a value on it. So long as there's not, a Renoir sitting on the wall, if you just basically go through the house. If it's basic American stuff, it's worth, several $1,000s, and that's about it. And the courts will accept that. If it's now for stocks, bonds, you need to get a broker involved to give you a valuation is the best way to do it. And also whether the stocks are certificated. If they're certificated, it probably is in your best interest to get them moved into an estate account anyway, quickly, so that they're easier to distribute or sell later.
Mm-hmm.
And you can get a value. And because you open an account with the broker, they're very excited, and many are willing to give you that date of death valuation for free, because golly, you just gave them an account.
Right.
So that's one of the questions to ask as you're interviewing them. And obviously, if there's an existing account with a broker, and they aren't willing to do that, well, then you can always move the account and get an inventory from one who will. So that's one thing to do, and you need the broker would know how to value the stocks to put on the inventory. The house, an appraisal is many times good to get, because your tax assessment, while fairly good in many jurisdictions in Northern Virginia, may not be the best number for you, may not be the highest.
Mm-hmm.
And so, I've seen situations where it was 20% too low, and I've seen situations where it's 20% too high.
Right.
So, again, it's always good to maybe hire an appraiser to do an appraisal of the real estate, particularly if it's land, raw land of some sort, or a farm, or if it's an investment property like a apartment building or a office building.
Right. Some people think that the tax assessment is the rule. I mean, that's like the hard line for the valuation of the house. But you mentioned the fluctuations, and that can be because a county simply hasn't updated in 5-10 years, or a county might overvaluate because they actually just need more money, right?
You don't know what triggers a county assessment. They're supposed to be highest and best use and fair market value,
Mm-hmm.
but you never know from the biases of the county assessor or what have you, or the needs for cash,
Right.
and certainly that can affect it.
Yeah. So previously you mentioned, paying creditors and kind of an order for who creditors to pay. One of the things that really upsets me is when unscrupulous creditors take advantage of families. And I just dealt with a situation recently in which a now single mother lost around $10,000 of the estate because of this. And I really hate that I didn't get to her sooner, because that didn't have to happen. What general advice would you give personal representatives, especially those without the benefit of an attorney, in regards to the creditors attempting to get accounts settled during the probate process?
Well, first off, nothing has to happen right away. So if creditors call you and are, saying, I want, you got to pay me now. The answer is no. I'll pay you once I've assessed what the estate assets are of the estate, and once I've assessed, what the debts are. And until then, I can't pay you. So be patient. We'll get to you when we get to you. The other thing you can once you do know that is you can go back to the creditors and say, I'm willing to pay you 50 cents on the dollar, and see if they'll take it.
Right.
Sometimes they will. You just make sure they give you back a receipt and a release for that, that they're not going to go back after you for the remainder. You do that, and generally speaking, that covers you. And if they won't do that, well, then you're paying what they're owed, obviously. But that certainly shortens it. The other thing is if you have a creditor that you really are not sure about, or a debt you're really not sure about, you can go to the Commissioner of Accounts, schedule a debts and demands hearing, and they have to prove up their debt. And that's more than just filing a claim. They actually have to show up and say, this is how the debt was incurred. This is his signature. This is the decedent's signature. This is what he did. This is what he bought. Pay us, and then that'll go a long way. And either it'll be approved or disapproved. But if they don't show up, the debt may be dismissed without requiring a payment.
Mm-hmm. Yeah. So speaking about the order of in which creditors are paid, some folks, they might have a car lien and think, well, I've got to pay, mom's car note, but then they're not setting aside money for the taxes, and the taxes take priority over that car lien, if I've got that correct. So can you give me kind of a generalized order in which creditors are paid?
Well, they're dollar limits, and I don't recall off the top of my head what they are, but there are, a portion of the funeral bill is a priority. I think it's $1,500 or something like that. Medical bills up to a limit, and I can't remember that limit, are a priority. Taxes are a priority. Administrative expenses are the top priority. So that means executor commissions, attorney's fees, and probate, those kind of things are the top priority. So the administrative costs always take precedence over any other debt. And then taxes are fourth. And then all other debts are then put together and are paid. Obviously, if you have a lien on an asset, if you don't pay that on a timely basis, it can be foreclosed upon or repossessed if it's a car. So you have that sort of dynamic. You got to decide, is it worth keeping the car? For example, if the note is $10,000, the car is worth $5,000, it might behoove you to just call up the lender and say, come get the car.
Right. Yeah.
And then let them be in line at the end of the line behind everybody else on the deficiency.
That makes a lot of sense, John. And the kind of nitty-gritty details that you're talking about are just not broken down and explained in the probate packet that administrators get when they become qualified. So having somebody like you in their corner, that's just once again so crucial if you've got anything that is at all complicated. Speaking of complications, in my experience, real estate and what to do with it is usually the most difficult part of the probate process for executors. In general, what do they need to do in order to sell any real estate in the estate, and how do they get the full authority to do this?
If they have a will, if the decedent had a will and he directed it sold, obviously that is, it must be sold. If in the will the decedent gave the executor the power to sell, the executor has the power to sell the real estate without the consent of the heirs, although that's always best of the legatees.
Mhm.
That's always best to do. If there is no will, then the administrator needs to get permission of the court to sell real estate, and some courts will grant it, and some courts won't unless everybody agrees. So, and because the title in Virginia vests in the legatees under the will, the minute the will is probated. So, or the minute a list of heirs is filed with the court, if there is no will. So they then own it. And that leads to more complications if you have one that wants to sell and one that doesn't want to sell. Well, then you've got to either negotiate it out, or you're going to end up having a partition suit to have the court order a sale, which is, means you probably are not going to get maximum value, and you're not going to get and it's going to lead to some bad feelings at the end of the day.
Right. About how often do you see the power of sale included in the will?
Well, it's in every will I draft, and if an attorney who knows what they're doing, is probably in just about every will. If the will was done by an attorney, if it's not done by an attorney, it may not be in there. In which case, then you have to then you can't sell it without an order of court.
Okay. And I apologize if I'm rehashing something that you just explained, but talking about the heirs, do the heirs, is it necessary for them all to agree and sign off on the chosen course of action for the real estate, or is that just something that makes it easier?
With regard, if the personal representative has been given the power of sale, you don't need them to sign off on it necessarily, but it's always good to do, because so they can't come back at you and say you sold it for too little, or questioned your judgment in selling it. You just say, look, I got the best price I could. This is what it is, and hopefully they'll sign off on it. If they don't, they may come back at you saying you didn't do your job correctly, and that's a red flag, I would say, if they won't agree to the sale.
So let's do a little hypothetical here. Let's say that there are 3 heirs, including the administrator. The administrator and 1 heir want to sell the real estate. The 3rd heir does not want to sell the real estate and wants to live in the real estate. What is a plausible course of action for this scenario?
Well, again, if there's no power of sale granted in the will, if there's no will and there's no power of sale, then the administrator would need to get court approval to sell it, and the recalcitrant heir would show up to say, I don't want him to have the power to sell. I want to keep it. In which case, then the 2 out of the 3 need to decide whether it's worth it to them to sue for partition to get the property sold,
right,
or open up some discussion as to horse trading. Okay, you want the house, the 2 of us will take the whatever other assets there are, and see if the dollars will work out to do that, or will you buy us out? And maybe give them a little break on the price and see if you can work something else. But unless absent an agreement, the vested heirs have rights in the property unless there's a power of sale.
Yeah, makes sense. So can you briefly explain what's involved in finishing the whole probate process? And by that, I mean, what boxes need to be checked and who needs to be informed?
Okay. If the personal representative is also the only beneficiary of the estate, they only have to file an inventory, and then 16 months after they qualify, file what's called a statement in lieu of accounting, in which they tell the court, I'm done. Or they can get an extension for another year to say, I'm not done yet. But I intend to file a statement in lieu of accounting. And at the end of whenever they're done, they file a statement in lieu of accounting, and they're done, and they don't have to account for every penny. If there are other beneficiaries of the estate, other residuary beneficiaries of the estate, that means the people in the residue clause or where there's no will, so the heirs at law, then you need to file a what's known as a accounting, in which case you have to account for every penny that showed after you file an inventory, and then you 16 months later have to file an accounting. If you're not done, then you have to file accounting, for a year later. So until you are done. So you account for every penny you spent. You have to balance it to your inventory. You have to balance it to what came in, what came out, and it all has to balance. And if you do that, then and you show vouchers, documentation, bank statements, canceled checks, receipts for your expenditures, then the court will approve it, and because they audit it, and they audit it very strictly. So it takes a while to get that done, but it's certainly something that you have to do to be absolved and released from the probate rules as the executor.
Yeah, it can all be just so complicated, and there can be such a large amount of minutia. My heart always goes out to folks who have been tasked with this. But this is the point where executors can get a sigh of relief and then move on with their lives. We've all got so much going on, and this whole thing can really be a cloud hanging overhead. So I think that's one of the reasons that people can grow resigned to the idea that it's just going to take as long as it takes, and that they'll only spend as much time as necessary at each step in the process so that it doesn't impede on their lives any more than it has to. But the problem with that way of thinking is that it often has the opposite effect in my experience. By actually putting out a bit more effort and being proactive on the front end, and getting the right professionals involved, they can save a ton of time and money so that they can get back to their normal routine as soon as possible. And that also entails getting educated about the process, as well as collaborating and maintaining open communication between team members like appraisers, clean out crews, etc. So I encourage anyone watching this not to hesitate in reaching out and seeing how folks like John and I can handle most of that for them. Not only are we going to do that in a more efficient manner, but we've got the resources in place already, so we know what to expect, and it's still a greater degree of predictability to the process, or as much as can be realized anyway. But John, once again, I want to thank you for being such a great resource today, and I want to remind the viewers that your information is going to be included. We'll also add a link to the Fairfax County Commissioner of Accounts website so that they can conduct, or they do conduct, monthly Q&A sessions for administrators. For those who don't want to navigate the electronic spaghetti that is the Commissioner's website, we include a link on our Facebook page directly to those monthly sessions. And for anyone who is not in the Northern Virginia, DC metro area, I want you to know that I still care about you, and I want to make sure that you've got the best resources possible. You can find my contact info via the links to our website or Facebook page, and it would be my honor to connect you with someone in your area who can be a resource during this difficult time. John, until next time, thank you so much.
Take care. Thank you, and if you need anything, holler. Thanks.
All right, thanks, John.